Did you talk to Stephen Miller?
I'm not going to describe the participants in conversations.
So you won't answer that question?
No, I will not, Senator.
Why?
Because it is not appropriate for me to discuss.
It is appropriate for you to tell us whom you consulted before taking action on behalf of the United States of America. You have no basis to avoid that question, Mr. Bove.
Respectfully, Senator, I'm answering that question in a manner similar to several nominees before me, including Judge Katzen.
Did you talk to anyone in the White House, including the president, about dismissal of the Adams charges before the February 10th memorandum?
I respectfully refer you back to my answer, Senator.
I am absolutely flabbergasted that you would come before this committee and refuse to tell us basic facts about a case that is at the core of the challenges to the appearance of impropriety that should disqualify you.
Emil Bove doesn't hedge. He doesn't deflect. He flatly refuses to answer. And that refusal triggers a stunning confrontation as Senator Richard Blumenthal accuses Trump's judicial nominee of open evasion, defiance of Congress, and creating the appearance of a quid pro quo that strikes at the heart of judicial integrity.
Senator Whitehouse raised this so-called deliberative process privilege. First, this committee and Congress have never accepted that kind of assertion as a basis to evade questioning in this kind of confirmation hearing. But I'd like to point out also that this witness has no right to invoke that privilege. It's a privilege for the government of the United States to invoke. Now, I notice that the Deputy Attorney General is sitting right behind the witness. I didn't hear the Deputy Attorney General invoke this privilege on behalf of the government of the United States. And I might point out also that the witness is invoking it selectively. When he wants to answer the question, no privilege. When he wants to avoid answering the question, he says he's not at liberty to answer it. We've never accepted that kind of tactic on the part of a witness. Yes, nominees have sometimes said they can't comment on a case or an issue because it may come before them as a judge. But this kind of selective invoking of a privilege smacks of evasion and defiance, and I think reflects on us as a committee if we accept it in this context, Mr. Chairman. So I hope that the witness may be instructed to answer these questions, or we can have a resolution somehow on the legitimacy of this kind of privilege and ask the witness to come back. Let me begin my questioning.
Mr. Chairman, I think the clock was started on Senator Blumenthal while he made his point of order. It might be a courtesy to allow it to be. Thank you. There it is.
I hadn't noticed that, Mr. Chairman, but I thank Senator Whitehouse for pointing it out. Thank you.
Let me say in the future,
Mr. Bove,
White House made very clear the issues you're bringing up, and I said I'm willing to discuss them. But
thank you.
We can't take the time of this committee to hear a repeat of everything from every member that would disagree with what I said in my opening statement.
I appreciate
Senator
your
Blumenthal.
point, Mr. Chairman. I'll begin my questioning. Mr. Bove, you responded to Senator Kennedy's questions about who was consulted about the dismissal of charges against Mr. Adams. Did you ever talk to Stephen Miller before you filed the memorandum on February 10th ordering the dismissal of the Adams charges?
Senator, I responded to Senator Kennedy's questions based on a publicly filed document that described the Attorney General as a...
Did you talk to Stephen Miller?
I'm not going to describe the participants in conversations.
So you won't answer that question?
No, I will not, Senator.
Why?
Because it is not appropriate for me to discuss...
It is appropriate for you to tell us whom you consulted before taking action on behalf of the United States of America. You have no basis to avoid that question, Mr. Bove.
Respectfully, Senator, I'm answering that question in a manner similar to several nominees before me, including Judge Katzen.
Did you talk to anyone in the White House, including the president, about dismissal of the Adams charges before the February 10th memorandum?
I respectfully refer you back to my answer, Senator.
I am absolutely flabbergasted that you would come before this committee and refuse to tell us basic facts about a case that is at the core of the challenges to the appearance of impropriety that should disqualify you. You have the opportunity to clear the air, to come clean with the American people as well as this committee, and you are evading and avoiding these questions.
Senator, if you have a question about the position that I took in public with respect to the Mayor Adams case, I'm happy to address it, and I've addressed several today.
Well, I have asked you a question that bears on the appearance of impropriety. Let me go on. Mr. Bove, in court, you represented, first, that there was no quid pro quo, but you said that the decision, even if there were a quid pro quo, was unreviewable. Unreviewable by the court. Do you stand by that?
I don't think that's what I said, Senator, because it's not consistent with the rule, which explicitly provides...
Well, you said it not only once, but you said it a number of times, and the judge observed, Judge Ho said, that your position was, quote, fundamentally incompatible with the basic promise of equal justice under law. That's what he said about your position, that the decision to dismiss these charges was unreviewable. Do you stand by that assertion?
I never made that assertion, and the judge granted the motion, Senator.
He granted the motion, but he disagreed with your premise that it was unreviewable. Let me ask you, are decisions to dismiss cases, as with that one, unreviewable?
The text of Rule 48 requires, in the instances presented by the Adams case, that dismissal only be provided for with leave of the court. That's as near a quote as I can give you, and the entire brief that I submitted acknowledged that point because we were seeking the leave.
Mr. Bove, I am concerned about the quid pro quo that the judge concluded had been done. In fact, he said everything here smacks of a bargain. Everything here smacks of a bargain. But the quid pro quo that really concerns me is the one that brings you here today. You were virtually the only attorney in the Department of Justice willing to go to court and make a claim that career prosecutors said violated their basic standard of ethics. And the quid pro quo was a nomination to the Court of Appeals. That's the appearance that the American people can take away from your sitting before us with that nomination. And I think it does grave damage to respect for the rule of law, notwithstanding your assertions about your adherence to it, for you to be here as a result of that stand by you. Let me ask you about a separate issue, the firing of prosecutors and investigators who were involved in the January 6th prosecutions. You were involved in purging prosecutors who, in good faith and an exercise of their prosecutorial judgment, they went to court, they brought charges, you purged them. Isn't that correct?
I don't agree with the use of the word purged, Senator.
Well, you fired them.
I authorized the termination of probationary employees at that U.S. Attorney's Office, yes.
Because they prosecuted the January 6th rioters?
No, because I was concerned about efforts in the prior administration to embed those prosecutors as permanent employees at the U.S. Attorney's Office.
And you also fired the FBI investigators involved in the January 6th prosecution, correct?
No, that's not accurate.
You worked with Director Patel in firing them, correct?
No, that's not accurate.
Senator Smith.
Thank you, Mr. Chairman. I'm going to pivot away from the Democrats' fake outrage.
This exchange becomes explosive the moment Emil Bove decides he simply will not answer a basic question. Not because the answer would violate the law, not because the information is classified, but because he claims he is not at liberty to say who he spoke to before ordering the dismissal of corruption charges against New York Mayor Eric Adams. That choice changes everything. Senator Sheldon Whitehouse opens the door by dismantling Bove's legal shield in real time. He explains something viewers rarely hear clearly. Deliberative process privilege is not a personal privilege. It belongs to the government. A witness cannot invoke it on their own. And yet here sits Bove, selectively answering questions when it suits him and refusing when it doesn't, all while the Deputy Attorney General is physically present and does not invoke the privilege on the government's behalf. That matters because confirmation hearings are not optional conversations. They are the Senate's constitutional duty to test credibility, ethics, and fitness for office. When a nominee refuses to answer factual questions about who influenced a major prosecutorial decision, it isn't caution, it's obstruction. Blumenthal then moves in for the core issue. He asks a simple, direct question. Did Emil Bove speak with Stephen Miller before ordering the dismissal of the Adams charges? Bove refuses. Blumenthal presses further. Did he speak with anyone in the White House, including the president? Again, Bove refuses. At this point, the tension isn't procedural, it's moral. Blumenthal makes clear why this refusal is so damaging. Bove isn't being asked about legal theory. He's being asked about basic facts that go directly to the appearance of impropriety, facts that could clear the air, facts that could reassure the public. And yet Bove chooses silence. Then comes the moment that lands hardest. Blumenthal lays out the context the nominee wants to avoid. In court, Bove argued that even if there were a quid pro quo behind the dismissal of the Adams case, the decision would be unreviewable by the courts. That position was so extreme that the presiding judge, Judge Ho, publicly rebuked it, writing that everything here smacks of a bargain and that Bove's position was fundamentally incompatible with the promise of equal justice under law. That judicial rebuke is not incidental. It becomes the backbone of Blumenthal's argument. Because the concern isn't just about Mayor Adams, it's about Emil Bove himself. Blumenthal spells out what many viewers may not immediately grasp. Bove was virtually alone inside the Department of Justice, willing to make arguments that career prosecutors refused to make because they believed those arguments crossed ethical lines. Those prosecutors quit rather than follow his orders, and now the same lawyer who made those arguments is sitting before the Senate as a nominee to the federal bench. That's where the alleged quid pro quo flips. Blumenthal suggests the bargain may not have been about Adams at all, but about Bove. Take the ethical risk, make the argument others won't, and receive a lifetime judicial nomination in return. Whether or not that was the intent, Blumenthal argues, the appearance alone is corrosive to public trust in the courts. The hearing then pivots to another pattern, retaliation. Blumenthal confronts Bove about his role in firing prosecutors involved in January 6th cases. Bove doesn't deny authorizing terminations, he reframes them. He says they were probationary employees. He insists it wasn't about January 6th. But Blumenthal's point lands anyway. Prosecutors and investigators who pursued the Capitol rioters were removed under Bove's authority. Taken together, a picture emerges for the viewer. A nominee who refuses to answer basic factual questions, a lawyer rebuked by a federal judge for advancing arguments incompatible with equal justice, a DOJ official who overrode career prosecutors and later benefited from a nomination, and a pattern of dismissals tied to politically sensitive cases. This is why Blumenthal's frustration feels so raw. The Senate isn't asking for opinions, it's asking for truth. And when a nominee declines to provide it, the damage isn't just to the committee, it's to the legitimacy of the judiciary itself. That's the lesson viewers should take away. Judicial independence doesn't begin after confirmation. It begins with honesty before the Senate. And when a nominee refuses to answer who influenced their most controversial decisions, the silence speaks louder than any testimony.